Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So today we have another in our chapter of lawyers acting badly, this time in Florida. I'll have more in just a moment. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys. So let's talk about some of the many things that went wrong in this case. Now, Strems was the sole partner and owner of the Strems law firm. And the firm's caseload, there were 3 litigation attorneys with each managing 700 cases. 700 cases. When you have 700 cases as a lawyer, you're not going to get to every court appearance. There's no way. When you have 700 cases, you're not going to get discovery completed on every case in the appropriate amount of time. It's just not going to happen. And it didn't happen here. And as a result, the firm was drawing between $5,000 and I think it said $15,000 a week in sanctions on these cases because they were not doing what was supposed to be done. Now, if that wasn't bad enough, the court found that there were a number of aggravating factors, one of which was that they had a lot of experience in the practice of law. And these 4 aggravating factors are the kinds of things that make courts much more likely to impose a more significant sanction. But the real problem here, at least from my perspective, was how badly the clients were treated as a result of this. Some of them had their cases dismissed outright. They were dismissed with prejudice. And some of the people who brought cases were aware of the firm's reputation and were aware of the lawyer and apparently felt like that gave them the right to bring frivolous cases and lie during depositions and in matters of import before the court. And here's what the court said about that. They said SLF's clients were sanctioned under Section 57.105 in some instances where SLF filed cases with unsupported claims. For example, in Mora versus United Property and Casualty, in what was referred to as a textbook example of the appropriateness of Section 57.105 to punish and discourage the unfettered pursuit of frivolous lawsuits, the court granted a motion for sanctions against plaintiffs and the firm, stating they knew or should have known that the plaintiff's claim was so devoid of merit on the face of the record that there was little to no prospect that it would succeed. The court sanctioned Mojica after finding his deposition testimony, sworn answers to interrogatories, and responses to requests for admissions regarding repairs made to the property to be untruthful. So, although you're working at a firm and you're probably making a lot of money, you're also destroying your reputation and putting your license in jeopardy when you work at a firm like that. Now, the lawyers all knew that, but for whatever reason, that did not modify their behavior in any way. So, the person who's at the top of the food chain here is the owner of the firm, and that's Mr. Strems, and it was his responsibility to fix this, and he didn't do it. Now let's talk a little bit about one of the cases where he really disadvantaged a client. Ms. Nowak is an 84-year-old woman who had her house damaged in a hurricane and sought insurance. And as insurance companies are often responsible for doing, they denied her claim. She had to sue them in order to get recovery. Now, the firm had a rather unique fee approach. Instead of saying, we have a 30% flat contingency fee, the fee varied as to whether it was settled before litigation or after litigation. Now, this is the fee agreement that the client signed, and it says that they authorize the attorney to file suit against the client's insurance carrier or other responsible party should they deny, reject, or underplay the claim. Then down below it says, in all cases whether there is a recovery of court-awarded fees or not, by contract or statute, the fee shall be 30% or of the amount awarded, whichever is graded. Now, in this particular case, no amount was awarded. It was simply taken, and you'll see here in just a second what I mean. So here is what the Florida Supreme Court said with respect to Ms. Nowak. Nowak initially informed SLF that she was willing to accept $30,000 as her pre-litigation bottom line, with Nowak receiving $22,500 and SLF receiving $7,500 in attorney's fees under the contingent fee agreement, which entitled the attorney to 25% of a pre-litigation recovery. However, SLF attorney Carlos Camejo was unable to obtain an acceptable settlement offer from the insurer in pre-litigation, and Nowak authorized SLF to file suit. After suit was filed, the insurer offered to settle the case for $30,000. When informed, Nowak stated she wouldn't accept this offer because she would have accepted it pre-litigation, but not afterwards. So, as a result of that, the lawyer turned it over to Strems, and Strems decided to negotiate personally with the lawyer on the other side. And Strems did a masterful job, but he did a more masterful job for himself than he did for the client. He was able to negotiate the following. Strems agreed to settle the case with the insurer's counsel, Matthew Feldman, for $45,000 without Nowak's consent or knowledge or consent. The client has to approve every settlement of any type. It can't be a situation where the client says, you know, you can just make the decision. They have to approve the settlement. And if they don't approve the settlement, there really is no settlement. But he settled this and then presented the paperwork to Ms. Nowak. Strems emailed Feldman's with directions to pay her $22,500 and the firm $22,500. So the fee went from 25% to 50%, which is, in my opinion, in such a small case, absolutely irresponsible of the lawyer. So the referee in this case decided that that was a reasonable fee because other lawyers charge 50% contingent fees. So he thought that was perfectly okay. But the problem was the way it was handled. The client wasn't given proper communication, and the issue of whether or not it was an appropriate fee came up. It says, we agreed that the referee erred in recommending that Strems be found not guilty. Nowak clearly sought a higher recovery due to additional expenses that resulted from delay in settling the case. So how did we get there? Well, the court says, when the insurer offered a higher settlement, Strems attempted to give Nowak her pre-litigation bottom line, which did not include the additional expenses she had incurred, and put the difference towards his attorney's fees. These facts do not support a finding that Strems abided by Nowak's objectives of representation. Therefore, we disapprove of the referee's recommendation and find Strems guilty of violating Bar Rule 4.1.2, which is the client communication rule. Now, in determining that it was a reasonable fee, the referee relied on an expert witness who came in and, gave the fee absolution. Here's what the Supreme Court said about that. The referee relied on Strems' expert witness who concluded that SLF's attorney's fees were not unreasonable or clearly excessive under the rule, and the fact that Nowak signed SLF's fee agreement, which communicated the basis or rate of the fees and costs, in finding that Strems' fee was not excessive under the fee agreement. And the referee found there was no conflict of interest between Nowak and Strems. But these findings are contrary to the record evidence. So essentially, the expert in this case just made a huge mistake. So that brought the case to the point where the Florida bar would then discuss the analysis, and they went through all of the information about the sanctions, the bad staffing, the way these firms were being hit with sanctions on a weekly basis, the fact that the lawyer who was responsible continued to take in new cases even though he wasn't adequately handling the old cases, and here's what they said. Additionally, the court, in its discretion, can impose a combined sanction for all cases and determine the appropriate discipline from the totality of the conduct as though all of the charges had been presented to the court in one proceeding. And then they go on to say this. Given the severity of Strems' misconduct, we conclude that the referee's recommended disciplines are not supported and disbarment is the appropriate sanction for these consolidated cases. I have said it, I know, a dozen times on here, but when you choose an attorney, you have to be very careful about who you choose, and that the attorney has time to work on your case, will work on your case, and does a suitable job on your case. Now, every attorney is human, and every attorney makes mistakes. Sometimes statutes of limitation are missed. Sometimes there are situations where a fact that you are unaware of as an attorney comes back to bite you. Sometimes your client lies. All of these things happen. But where you are not doing your job of keeping up with the docket, of getting things into the court in a timely manner, and of satisfying your obligations under the rules, you deserve whatever discipline the Florida bar hands out. And in this case, they disbarred Mr. Strems, which is a completely reasonable finding. Now, my purpose in making this video isn't to abuse Mr. Strems or embarrass him further than this case has already done. My purpose is to let you know that the client has some responsibility in every case to keep an eye on their lawyer, because they are just like if you go out and you hire an electrician to wire your rental house and you hire a bad electrician and your rental house burns down, there's a possibility you could be liable for that because you didn't supervise your employee. Well, in this situation, you are the employer and the lawyer is the employee, and even though you shouldn't have to supervise them, in the real world, you should look over your client's shoulder. I've had situations where clients caught misspellings, where they caught inadequate turns of phrases or things that they felt were ambiguous. Well, if my client thinks it's ambiguous, then certainly somebody else is going to think it's ambiguous, so you have to fix it. That's what the law is. That's what lawyers do. That's what good lawyers do. And if you have to sue somebody, or if you get sued and you have to defend, you need somebody who is going to dot the I's and cross the T's. And that's the purpose of this video. So I hope you found something interesting to take out of this. I will link down below the case on the Florida Supreme Court's website. It's there for anybody to read. It's public information at this point. If you have any questions about this, feel free to leave them in the comments down below. Otherwise, thank you for watching. Oh, and by the way, if you're subscribed, you're probably seeing a bunch of t-shirts down below, a lot like the one that I am wearing here. You know, careful or you'll wind up on my YouTube channel. Actually, the one that you can get here on the channel says that, you know, careful or you'll wind up on his YouTube channel, meaning mine. At any rate, if you want to support the channel and you find those t-shirts funny or useful or helpful, there are some on there about kindness, there are some on there about the law, there are some on there about sovereign citizens. All the funny stuff is on there. I believe in laughing and having fun. If you can't laugh, you can't learn. So if you would like to contribute to the channel in that way, the t-shirts are printed on demand and they'll be shipped to you within a week of you ordering them. So again, if you want to support the channel, they're there, but you don't have to, absolutely. Thank you so much for watching. Please like, share, subscribe, and I will catch you on here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.